I've known Donna for a while, and I'm really excited because I've been looking for someone that is really also focused as an attorney on the changes in the social space, online liability. She'll give you more of what she covers, but this has been excellent. I've referred her to clients. I hope to refer her to more clients. And I really wanted to get somebody that would be kind of a partnership with the class and understanding and thinking about these constant changing liability risk where the laws in some areas hasn't been fully proven yet. So we need someone that knows that versus just, the easy button for the attorneys is don't do it.
All right. Welcome. Thank you for having me. Just to give you a sense of where I'm coming from, I've been licensed more than 20 years now, which astounds me. I've always practiced in the field of business law, transactions, which means not litigation. I help people start businesses, I review contracts, I help people buy and sell businesses, I help with commercial real estate transactions, and I do what we call soft IP, which means not patents, trademarks, copyrights, licensing, trade secrets. And I became enamored with social media myself as an attorney who was responsible for generating my own business. And the parts that I gravitated to were the parts that would make me a subject matter expert. I've been blogging since 2010. I blog every week almost now. Every Monday morning we send one and put it up. I do some on Facebook, some on LinkedIn, and then I have a teenage daughter so I can keep up with everything else. Those are what's important to me. And it's really interesting to me, as you can see, OMG, teenage daughter, right? Oh my gosh. There's social media law. That's what people say often when I tell them I can advise in social media law. There's law for that? Yes. It's really not entirely new law. The technology is a little different, but the law is the same. So I have a picture of a rotary phone up here because, I now have the phone in my pocket. You can wear the phone on your wrist. But the basic technology of calling someone is still subject to a lot of the same laws. And as you're going to see, it's all going to be old law applied to a new medium. And what I'm going to do today is give you an overview. This is the 101 class, not the graduate level class, of the law that underlies social media. I'm going to give you a bunch of examples of how it would happen in social media, where you go wrong, what it would look like in real life. I'll take some questions, but this is really pretty general, and I don't want to get too far down into somebody's specific situation. There is no specific social media law. It is a real patchwork quilt. There's some trademark, there's some trade secret, there's some copyright, there's some privacy, there's some defamation, and then there's some government regulations from agencies such as the Federal Trade Commission. Believe it or not, there is a lot of social media law on employee handbooks and what you can tell your employees about how they use social media law. And to be honest with you, I find most of the decisions just ludicrous and stupid, and they make no sense to me, but they're there, and we got to pay attention to them. All right, social media. That stuff you write and you send out to the world. I never in a million years thought that I would be standing here and telling you about what the trade secret parts of social media law are, because that just sounds like an oxymoron, social and secret. But where it, first of all, here you can read trade secret. Basically, it's something that you keep secret and you get a commercial advantage over your competitors for it being secret. That's, stand on one foot, tell you the law. That's what trade secret law is. It comes into play mostly with customer lists. And I know Martin had sent me some of your questions. Somebody had some questions about LinkedIn. There's two big cases in this area. The first one is on LinkedIn. This is Ms. Eagles. She is like a doctor in banking, like a PhD doctor, economics. She was hired by a company called EdCom, and they created a LinkedIn profile for her, put basically her resume on there. She had some contacts. They encouraged her to put all of her contacts on there so that the company could help her. She really wasn't, from what I can take from the case law, computer literate. So she had assistants that did this all for her, probably the PR person at the company or her secretary or her personal assistant. She gave the password to people. They put all her contact on there, and she got some contacts that were customers already of the company, and they said, "You're our new CEO. You put those on your LinkedIn. We'll put the updates for you." And over time, she added more information, such as people's cell phone numbers, their addresses, notes about things. And then she got fired. And the company just took her LinkedIn profile and basically changed the name in the picture and gave it to the new CEO, Sandy somebody, I can't remember her name. And she sued them for
the new one or the old
one? The old one. Basically for all kinds of state law claims, that they stole her identity, they interfered with contracts because people couldn't figure out how to get in touch with her anymore to do new deals. They were misappropriating her rights to publicity because that's her background and her profile, identity theft, conversion, which is where you own something for one purpose, but then you convert it to another use. I once heard it's a legal form of theft. It's not really legal, but it's a form of theft. It's a legal word for theft. Civil conspiracy and aiding and abetting conspiracy. And that was really the first time anybody had sued over a LinkedIn profile. What she didn't sue over, what didn't happen was the company didn't sue her for trade secret misappropriation. But, so it's all her identity. And she won on some of the counts. The court found that her employer did misappropriate her identity and invaded her privacy. But she didn't show that she was damaged by this. She didn't say, hey, I lost these 6 deals or my income went from this to this. What she tried to say was, well, last year I had X number of contacts in LinkedIn and my salary was Y. Therefore, every contact was worth X dollars. And the court says that's very speculative. Yes, they stole your identity, but you won the case, but we're not giving you anything because you didn't show us that you lost money. But what it did show was that LinkedIn is worth something, and you need to be very careful about what you tell your employees about who owns what. I'm going to show you another case of how this comes out.
What year was this? Was this recently?
This was, the actions occurred in 2011. The case was 2013. This is my phone dog picture. Phone Dog is a company, I don't even know if it's in existence. I am not their target market, so I never heard of them. But they do technology reviews of different products, phones, hardware, software, programs, and mobile news and reviews is what they said in the court case. But I think it was more technology. You know, if I were going to buy a new phone, let me go see what Phone Dog thinks about it. They had an employee named Noah Kravitz, and that was his Twitter handle, PhoneDog_Noah. He got, I think, 17,000 Twitter followers and really built up the services of Phone Dog, had all these followers, and then he left employment. When he left, He changed the password on Twitter and changed his handle to Noah Kravitz. That's his name. PhoneDog sued him and said that password that lets us, and so is our trade secret. You have violated our trade secret because you used the company's password and took these 17,000 followers of the company, which are company property, and you got these contacts to sell our services, get people to our site, see our ads, and therefore you have stolen our stuff. And Noah said, are you crazy? Every single one of my followers, if you went to my Twitter site, you could see them and you could go ask them to follow you on your own Twitter. This was all my hard work. Get lost. It ended up getting settled. But again, what the point I want you guys to take is that it is not clear who owns what just from use. And what you need to do is, if there are things that are important to you as a company, set a policy, social media policy for it. So when a new person comes to work for you and they're your social media manager or brand manager, or they're just an assistant that you give random tasks to, but you let them be on Twitter or Facebook or post stuff on LinkedIn or send out email campaigns, you want to be very clear what the company owns and what they own. And it's very good to say, hey, Phone Dog Noah is the property of Phone Dog Company. And all the followers that you are attracting are ours. That's a lot easier, I think, on a corporate Facebook account or a corporate Twitter account. If you follow a lot of the people in the media, they'll have a handle that'll say, Donna AP or something that lets you know, at CBS News Donna, something like that. You can do that with other companies too. I think that's very clear that that's a company asset and not a personal asset, but you can see how that gets very blurry. If you want it to be a company asset, you need to set that up ahead of time. You really want somebody besides the individual employee to have passwords to the accounts, because a lot of case law gets made by disgruntled employees who run off with things, won't change passwords, won't disclose them, do malicious things, and you can't change it. You have a question?
So if you had them sign a contract acknowledging that it's the property of the company, would that hold up in court? Would that protect you further? Is my question.
Yes.
So
Yes.
So your policy should include a signature? Or
I would do it however you do all your employment policies. Some people say, here's a handbook, sign that you've received it. Some people have a training program where they go over. It just kind of depends.
Okay.
But it's very important to clarify. It used to be that customer lists were some of the most highly protected trade secrets that there were. Who are your salesmen calling on? Salespeople. But that's on LinkedIn now, and you're encouraged to go connect with your customers and your prospects. And so, I think LinkedIn is the most troubling one of, is it personal or is it the company? And almost every case I've seen, it's really been a personal asset. It's your profile, your contacts, but sometimes you need to really be thoughtful about who you're connecting with, and should that be public? I never connect with my clients. They can connect with me, and if they ask to connect with me, I will accept it. But who my clients are is confidential information. And if somebody looks at my LinkedIn profile and says, how do you know Martin? I can say, oh, I teach with him at social media, or I've bought stuff from him. But I can't say, oh, I'm his lawyer, because that's his information to disclose, not mine. So, think about that. Copyright law. I want you guys to think, it's spring. A lot of people are doing Get Ready for Spring Buy My Services newsletters. And you want to pick them up and perk them up with pictures. I don't think anybody in this room would go to the library and say, oh, that's a beautiful spring picture. Let me take an X-Acto knife, take this picture out of the book in the library and paste it onto my newsletter, right? People do that online all the time. This portion of the seminar is called Just Because You Can Right Click Doesn't Mean You Should Right Click. This is all the things that are subject to copyright. For most of us, it's very visual. It's things we write, pictures, artwork. Just so you know, it could also be music, both the sheet music and the performance of it. Those are two different rights. Sculpture, dramatic presentations, dance. Pretty much, copyright was intended to protect artistic works. It's in the Constitution that artists have some incentive to create art because they will have some way to profit from it and exclude other people. And that's the copyright. You don't have to register anything to get a copyright. You get rights in your work the moment it is fixed in a tangible medium of expression. What does that mean? You write it down. Not only do you not have to save it on your computer, as soon as it goes in the cache in your computer, that is fixed in a tangible medium. When you take the photograph, whether on film or in digital, there are ways I understand there's notations for choreography. So you write down the choreography or you take a video of it. So as soon as you have your creation and it's fixed, you have rights. What is not protected? And I think this is going to help you guys figure out what to do with memes and tweets and other things other people post on social media. Ideas are not protected by copyright. So I could write a story about a little boy that's lost in the jungle and raised by apes, right? That's an idea. I cannot call him Tarzan. That's somebody else's expression of that idea. So the idea itself is not protectable. Your particular expression of the idea is protectable. And if you think about how many paintings there are of Madonna and Child, everybody has their own expression of something like that. Everybody has their own expression of what a flower looks like. And as long as you are creating your own, you're okay. Natural phenomenon are not copyrightable. Facts and forms are not copyrightable. So the first person that created the white pages took a lot of work to get everybody's name, address, and phone number and put it in alphabetical order. He could not copyright it because those are just facts. There was nothing creative about it. It's not subject to copyright. There are business forms and accounting forms that have been tried to be copyrighted. Those are so linked to the facts that there's really only one way to present it, and it's not original, and there's no copyright in that. Functional items are not copyrightable. And darn it, I forgot. I have this very beautiful, my favorite color is purple. And my kids bought me this very decorative utility knife. It comes in a purple plastic sheath, and the blade is purple, and it has curlicues etched in it. The purple and the curlicues are copyrightable because that has nothing to do with the function of a knife, but just a generic knife with a silver blade and a black handle or a wooden handle. That's not copyrighted because there's nothing distinctive about it, and you really can't take that to your own and make other people stop using it. Copyrighted material has to have some degree of originality. When I was in law school, the professor said it was this much. Just have to be the slightest bit original thought to it, changes. So think about that with really short works like song titles, movie titles, slogans. Those are not considered original, and those are not copyrighted. What is a copyright? Copyright is a bundle of rights. If you are the author of a work, you have the right to copy, to distribute or sell, if it's a visual art, to display it, to modify it or create derivative works, and I'm going to go into what that means in a little bit later. If it's something that can be performed, you have the exclusive right to perform it, and to play your digital audio if you have digital audio. So any one of these rights can be violated. Usually it's impermissible copying and distribution or sale. You only can prove copyright from circumstantial evidence. Did the person have access to your work, and is it substantially similar? And as you can imagine, those are sometimes hard to prove. Sometimes you could say, I never had access to that. You know, he published it over in Oregon and he never put it online, and I had the same idea in North Carolina, so I didn't have access. I didn't violate his copyright. All right, derivative works. This is my favorite example of a derivative work. This is a photograph from a rally that Obama did, I believe when he was a candidate. Yeah. And that was an AP picture. This artist saw that picture and went, wow, and created this poster to sell to raise funds for Obama. And AP sued the artist and said, this is our copyrighted photograph. This is a derivative work. Derivative work is like Andy Warhol and the soup cans, where he creates one and then he does them in different colors or different angles, but it's his idea, his expression. He just kind of changes a little. Derivative works can be if you take a photograph and then you recreate it on canvas, or you have a series of works that play off each other, and you have the right to do that. But someone can be inspired by your idea and go off in their own direction. And that's not a violation. That's kind of why, you know, art's so cool, because you get inspired by people. It's a fine line sometimes. So, you know, what do you do with this? Who buys the AP photo? Other news organizations that want to use this, people that are doing biographies and want a picture of Obama. Very kind of documentary. Would anybody that was buying that original photo be confused and think that this poster that's not a photo and is more of a campaign slogan, and would they be confused? Does it have a different purpose? Yes?
What if they had bought the actual copyrighted photo? They paid money for it, and now they have the photo. It's just like if I had used it on an article I wrote about Obama.
No problem.
No problem, but when they transformed it was the issue.
Well, when they used it without permission as the basis of another work. You know, should AP be getting royalties because it's based off their photograph?
So did they actually pay for the photo?
No, he just saw the photo.
I wonder if they had paid for it.
This one actually settled out of court privately, but most commentators think that the poster was transformative of the original work, didn't disrupt the marketplace for the original work, and it was okay to use that as your inspiration. This is a photographer who happened to be in Haiti during the earthquake a few years ago. And he took that and he tweeted it. Another woman, I believe it's a woman, another person downloaded his picture, copied it, and then tweeted it again. She didn't just retweet it, she tweeted it again as if it were her own. And then some big media outlets, I don't speak French, but Agence France Presse, and Getty picked it up, licensed it to hundreds of people, cut the original photographer out, and the photographer sued them, and AFP said, no, it was on Twitter. That means he was freely distributing it. It was fair game, you know, the fact that he freely distributed, they got licensing fees, but you know. The photographer won $1.2 million in statutory damages for willful infringement.
Yes!
So that's how it happens. You know, I think if anybody had retweeted the original one and said, wow, look how bad this was, this photographer was there, I don't think that would have been copyright infringement. But the fact was that they passed it off as their own. I think that's pretty classic infringement. Again, like very minor changes in the fact pattern can change the outcome.
I just have a question just about the photo, kind of, okay, we know the photographer got paid, we know that also Getty got paid, but what about the woman? What if somebody takes my picture and then uses it for whatever purposes?
Mm-hmm.
Do you
All right.
have any legal rights?
There is, I'll get into it a little bit at the end, that comes under the right of privacy and the right to control your likeness. I can tell you that if there's a case we studied in law school where the guy cut out of work and went to a baseball game. And they picked him up on the Jumbotron, and it got put on, you know, the local channel that covers the baseball game. And his boss saw him at the baseball game. He sued, I don't remember whether he sued the ballpark or the, because you didn't have the right to put my face on the TV. And they said, you're in a ballpark. You have no expectation of privacy in a ballpark. So if you're somewhere in public,
She's in public, but she's under rubble and there's another body right beside her.
right, and there's often a news exception,
Okay.
you know. So anyway, but yeah, that is something to be concerned about.
Okay.
And I don't know what the law is in Haiti, so. All right, you don't have to register your works for copyright, sort of. Sort of. You don't have to, you remember, your rights to the copyright attach the moment it's fixed in a tangible medium. However, you cannot sue in federal court to enforce your copyright if you haven't registered it. So, you know, there's a big old asterisk by that. The other really cool thing about if you register your work, for people that are doing 3 or 4 works in a year, that's not a huge hurdle. I think it's $50 now for each work. But for people like photographers that have thousands of works, that is prohibitively expensive to register every single one. And so what do? You can pick a few that you want to commercialize. It's all a cost-benefit analysis, and I don't have a good answer for it, but you know, you can register your websites, you can register books that you write, software programs. And when you register, you can get statutory damages. Actual damages are, oh, he copied my picture and I would have sold 30 of them this year at $10 each. That's, you know, $300 in damages. It's not worth to sue for that. But if you've registered, there's these things called statutory damages that in the statute talk about how much you can get per work. If it's innocent, like, oh, I heard this tune and I didn't realize it was yours, but I didn't like go out and purposely, you know, I didn't download your picture from Twitter and send it out as my own, that's much less. If it's willful, you get a lot more because we don't like willful infringement, and you can get attorney's fees.
And you were mentioning.
All right, so there are a lot of myths out there about what you can use. And I know the print's all over the place, but I really like that picture and the white of the baseball player at the bottom sliding into base messed up the white print, and everything else messed up the black print. So I hope you can see it. There are a lot of things people do with copyright. Remember this book. You know, if you would not cut out of this book, would you cut out of this book if you were using it for a nonprofit? Would you cut out of this book if, oh, well, I'm just a teacher and I'm using it for educational purposes? I only took one picture. Look how thick that book is. You know, think about these ideas of, oh, I can just copy it because it's a little, or I'm a good person and I'm using it for a good cause. Everything on this list is what we would call a fair use argument. There is a defense to copyright infringement called fair use. Defense. That means you have been accused of infringement, and this is your defense. It is not a, I get to do it freely. It's, I did it and I have a good reason under the law. Fair use is hard. Fair use is not determined until the judge finds it, and it's based on 4 factors. Each one of those is weighed independently. They'll look at the whole facts and circumstances. They're going to look at, who are you? Are you a for-profit business? Are you a nonprofit? Are you an educational institution? What was the original work? Was it a news column where it's mostly facts? Was it a novel someone spent 5 years writing? How much did you take? Did you displace the market for the original work? And not one of those is more important than any of the others. There is a case when Gerald Ford left office, he wrote a memoir. And he had chapters that were going to be published in some magazines as publicity that got stolen. And somebody published about 3 or 4 paragraphs from this 400-page book without authorization. And they got sued for copyright infringement, and they said it's fair use. You know, we used, 4 paragraphs out of 400 pages. Well, the 4 paragraphs that they excerpted were where he explained why he pardoned Nixon. And the court said, you know what? A lot of people were going to buy the book just for those 4 paragraphs. Willful copyright infringement, don't do that anymore. Ideas are not protected. Yeah, but the more... So there was a case for one of the Star Wars characters. And you can do a robot. You can do a robot that only talks with bells and whistles. Can you do a robot that's this tall and has a round top? And can you call it D2R2? Like, the more similar it is, the more likely it is to be copyright infringement. And again, it's a sliding scale. They just do it case by case. So, we're going to do a movie. It has 2 robots that are friends. One of them interprets for the other. I'm not sure that gets to the level of violating a copyright, but the more similar and the more detailed it is, the more it does. So when I do some of my social media talks, I have this one really cute picture about social media defined through bacon. And it's Twitter. Here I am at social media class eating bacon, and Foursquare, I just checked into the restaurant to eat bacon. It goes through all the different media like that. And it's actually somebody on an easel in a class writing that out, and they took a picture of it, and it's on Creative Commons, which is one of those places you go. And so you click on it, you see what the license is. The license says free to use, but attribute it to the owner. The owner didn't have his name anywhere. Like, I could not find out who wrote that, who took the picture, whatever, who posted it. So I used his Flickr handle, which was all I could find. So, it's not always as easy as you think it is. So what I say is use those.
So you should say photo credit ABC.
Yeah. Because, but it was photo credit, AK_Alaska or something. I mean, it wasn't a person. That was all I could find. You'd think if that was his price for using his photo, he would put his name there. But, all those free sites, read their terms and conditions and make sure some of them you can. This is what I'm finding for some of my clients that get logos created for trademarks through some of the freelance sites, is they give you your logo, but you're only allowed to make 200 copies of the image or something crazy like that. So the devil's in the details.
Oh my gosh.
The Smithsonian Institute, New York Times have public domain places where you can go and see archived materials. So, you know, create your own original content, hire someone, graphic designer, photographer. When you hire them, you want an agreement that says when you pay them in full, they're going to transfer the ownership of that to you. Because when they fix that photo or that logo in their tangible medium, they own it. You'd think that you hired them and they agreed to create it for you, that you automatically get the copyright. You don't. And a lot of people get tripped up there. So, you know, always make sure that they assign the copyright to your work to you. Public copyright, oh, I didn't tell you this. Copyright lasts right now, life of the author plus 70 years. And the copyright law has changed dramatically over the years. So right now, things that are clearly in the public domain were created in 1923. And if you think about what might have been relevant about 100 years ago and would you want to use that today, there are things that are in the public domain. It is so hard to figure out because you used to have to renew copyrights and it would be life of the author plus a certain amount of years, and they kept extending it because Walt Disney has been dead about 75 years now, so watch that. They're about to get Mickey Mouse in the public domain as a copyright. And so Disney's been lobbying like crazy for about the past 20 years, and they keep extending how long a copyright lasts. Ask somebody permission. Hey, I saw this, that phone dog picture. I saw that on a vet's website on the contact page, and I emailed her. I said, hey, can I use that? That's so cute. Because I was Googling images of phone and dog for that slide. And she says, oh no, I got it from a stock service. So I found that service and I got permission to use it. But, you know, hey, I saw your blog. It was great. Can I quote it? Can I link to it? Can I use it for inspiration? I'll give you credit. Yes. I mean, just keep the email. There's no magic language.
Just have a quick question about tattoos. What copyright? Like, if you go to a tattoo artist and see all of those images, and you're like, I want that one, or you pick an image from the internet and say, I want that on my body.
You know, there's a case on that, and I can't remember how it came out, but there's a celebrity that's got tattoos everywhere, and they used his likeness, I think, in a video game, or they took a picture.
Basketball player?
Maybe. And I know there's case law, and I don't remember it. I think that's a hard one, you know, because I don't think another tattoo artist can copy their works. I think those are the copyright material of the artist, but it's your skin, you know, people can take pictures of you, again, you know, for, I don't know, I'll have to review that tattoo case, yes.
Are fonts copyrighted?
Some of them are. Like the, I mean, some people, when they do their branding and their trademarks, they create a font for you, and that's what you use for your logo. I would, wherever you're getting it from, look very carefully what the rules are.
Because I know Walt Disney, they've got their own. Of course, it could be a little different.
Most fonts are copyrighted.
Okay.
Lots of them are used publicly, or Microsoft has released them. But the good ones, trust me, the good ones cost money.
Okay. So if you pay for them, you're free to use them.
Well,
I buy a license for the ones I want to use.
You have to read how you can use them.
you can use them.
Okay.
All right, we're going to move on to trademarks. Trademarks are brands. What is a brand? If I had each one of you were a branding expert, you would all give me a different answer to what branding is. But basically, it is how people feel about your product. And then you want them to feel that when you see certain things associated with your product. It could be a word or a name, like Pinterest. It could be a logo. I mean, I think the two logos I put up there, you can look at those and know exactly what those products are and if you like them or hate them. It could be a slogan. Remember I said copyright is not for slogans? Trademarks are for slogans in some instances. You guys know what that is? Coke bottle, not soda bottle, Coca-Cola bottle. That is a trademark. That is scented yarn. That is a trademark of that company because it is non-functional. Yarn does not have to be scented. So they scent their yarns, and that's how you know it's from that company. I spoke to a group of people that have custom fabric and textile businesses. They do interior decorating, slip covers, and cushions and things like that. It's the only group I've ever spoken to that has seen that product in real life. Old Spice Sound is trademarked. The MGM Lion Roar is a trademark. You guys know what this is? TGI Fridays. The look and feel of a restaurant can be a trademark. The old McDonald's used to have those golden arches at the front. That's a trademark. When you used to drive to the parking lot and drop your film off in the little kiosk and come back an hour later and drive around the other side, they hand you pictures. The photomat booth was trademarked, the building. Do we know what comes in this box? Jewelry. Yeah. that color blue is trademark associated with Tiffany. So pretty much anything that identifies your company as the source of a good or service to the public can function as a trademark. Most of the time for social media, we are concerned about the logos, the stylized Pinterest font. If I put a Ford logo up here with the oval and the stylized Ford or the stylized words of Coca-Cola. Have you ever seen the t-shirts? They're really old now. When I was in high school, they had them. It said, "Enjoy cocaine." And it was written in red letters on a white and the Coca-Cola font. Coke didn't like that too much.
But they can't stop that, can they?
Depends. There is some room for parody, but there is also some room for casting your product in bad light.
You always see like people that will copy the look of a trademark and just change the word. Like if they had, I remember when I was abroad and somebody had like store Ann Taylor, they just changed it to like just Taylor or some other Mary Taylor, but it was the exact same logo, exact same.
Right, right. And if they hadn't registered in that country, it would be hard for them to stop. There was a case, North Face makes outdoor clothing, and somebody did a parody of that called South Butt, North Face South Butt. That was found to be trademark infringement, which I thought was crazy. But trademark, so copyright, patents, trade secrets, that protects the owner of that IP. Trademarks protect the public and the consumers. It is a consumer protection statute. And the reason for that, I should have put the slide in. If you've ever been to the dollar store and you know they have a jug of fabric softener that's in a blue jug, but it's not Downy. It has a name that starts with D that's in dark blue script. That's what trademark protection is all about, so that people don't go to the dollar store and think they're buying Downy and get home go, "Ooh, this smells different. This must be a bad batch. This didn't work." You know, the orange jug of detergent didn't clean my clothes, and I think there's something wrong with Tide. That's really what trademark infringement is about. Can you find the source of what you're trying to buy for the price point and the quality you want to buy it? So what is trademark infringement? Again, it's very loose statute, very loose definition, because you have to weigh all kinds of factors. But basically, are you using a mark that is substantially similar to someone else's and likely to cause confusion with a typical customer? All right, so standard for trademark infringement is likelihood of confusion. Greatest show on earth. Circus. You have to pick a new example because there is no more Ringling Brothers circus. This says greatest snow on earth. And it's for a ski mountain in Utah. I think one of the Utah visitors bureaus or tourism bureaus created that. Ringling Brothers sued them. Court said, nope, nobody is going to think, greatest snow on earth is in any way associated with the circus. That's not likelihood of confusion. That's not infringement. One of these shoes is from Gucci. One of these shoes is from Forever 21, which is what they call fast fashion, which copies all the trends and sells them for really, really cheap to teenagers. And it's largely the green and red stripes that got them in trouble, because that is trademark of Gucci. How does it come up in social media? This says, I fix Fords. Ford is a registered trademark of somebody else. He can say this truthfully, that he fixes Fords. That's called fair use. If you want to be technical, it's called nominative fair use, because you're naming a brand that you have an affiliation with. So you can say, you know, this podcast is usable on a Kindle device. This store sells Levi's jeans. Anything that you can do factually, for the most part, is fair use. There are some really quirky brands. So I had a client that has Teflon in their product. And on their pricing sheet, they said such and such with Teflon, and they put the R beside it because they know it. DuPont owns the word Teflon. You can't even advertise truthfully that you sell something with Teflon in it unless they give you a license. That is in their sales terms. And I wrote them the nastiest letter, and they wrote me an even nastier one back. There are, you know, you can't say I repair Microsoft products sometimes if you're not Microsoft certified, that kind of thing. So it's not a complete use, but for the most part, as long as you're truthful. All right, here's another one. This may cause the program to go south again.
No, go ahead.
All right, because I have another embedded video. This is called United Breaks Guitars. And this comes under the United Sucks kind of websites, which you're allowed to have, because those are opinion. But this was a musician who was on a plane. They made him check his very expensive guitar. They are sitting on the tarmac waiting for the doors to open, and people start saying, hey, look at that. And the baggage handlers are just throwing the instruments. And United was like, oh, there's a $50 or $200 damage, and that's all you're going to get. So he did this. All right. So what do you do when somebody's infringing your stuff, your logo? You know, first you got to be able to find it. So you need to have some system for, they call it policing your mark. I have a Google alert for legal direction because that's my company name. So anytime that comes up, it's never once been infringing. It's all these crazy cases about laws, often in other countries. But you want to be able to know that somebody is infringing you, and you need to have either a service that you hire or Google yourself every once in a while. You know, your customers may say, hey, you know, I saw this website. I thought it was you. What's going on? Trademark law is really complicated. You can file a federal registration, which gives you exclusive rights in the entire United States, no matter where you're using it. You can file a state registration, which gives you exclusive rights everywhere in North Carolina, no matter if you're all over the state. And if you do nothing, you have common law trademark rights. Those I hate because you're allowed to use it in your geographical location plus a reasonable zone of expansion. So if you have a restaurant in Winston-Salem and somebody uses a very similar logo in Asheville, is that a reasonable zone of expansion? Is Greensboro a reason? I don't know. I don't like them. So if you care about it, get a state registration. But you can write them, say, this is my trademark.
Right. They won't pull
They
it.
don't care.
Yeah.
All right, so you find your infringer. Need to really think about who is infringing you and why. I'm going to read you a little bit from I always call this, do you want to be Starbucks or do you want to be Jack Daniels? Starbucks has a web crawler that every time one of their trademarks is used in an inappropriate way, they get basically a form letter sent by a law firm. And it goes something like this. We represent Starbucks Coffee Co., DBA Starbucks Coffee Company, and its subsidiaries, collectively Starbucks Coffee Co., in trademark matters. As you probably know, Starbucks Coffee Co. is the owner of a number of world-famous trademarks, blah, 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 blah. It recently came to Starbucks Coffee Co.'s attention that Exit 6 Pub and Brewery, LLC, Exit 6, is using the mark Frappuccino in connection with a stout-style beer crafted by the brewery. This is a 3-page letter that demands they stop, they send damages, they certify that everything they've done is destroyed. The owner, so what you need to know is Exit 6 Pub is like this pub at a crossroads of a town that has like 200 people in it. I don't think there's a Starbucks in the entire county. And somebody compared this stout beer to a Frappuccino in the comments. So it's not even that the bar was saying, hey, this tastes just like a Frappuccino. I didn't even know Frappuccino was a Starbucks created term until I read this case, which is another issue. But he basically wrote them a letter back that says, Exit 86, I represent Exit 6 Pub and Brewery. I'm writing in response to your letter dated 12/9/13 in regards to the Frappuccino, at risk of further lawsuits, heretofore known as the F word. Offers to pay him his 6 cents in profits from the 38 drinks. And these went viral, and Starbucks just got ridiculed because, I mean, number one, it wasn't even infringement. It was a web crawler process that went crazy, and it made Starbucks look ridiculous. If you can see down here, this is a book from somebody in Tennessee, and this is Jack Daniel's label. Here's the letter from Jack Daniel's in-house counsel. I'm attorney for Jack Daniel's. We're the owner of Jack Daniel's trademarks, which have been used extensively and for many years in connection with our well-known Tennessee whiskey product and a wide variety of consumer merchandise. It has recently come to our attention that the cover of your book, Broken Piano for President, bears a design that closely mimics the style and distinctive elements of the Jack Daniel's trademarks. An image of the cover is set forth below for ease of reference. We are certainly flattered by your affection for the brand, but while we can appreciate the pop culture appeal of Jack Daniel's, we also have to be diligent to ensure that the Jack Daniel's trademarks are used correctly. Given the brand's popularity, it will probably come as no surprise that we come across designs like this on a regular basis. What may not be so apparent, however, is that if we allow uses like this one, we run the very real risk that our trademark will be weakened. As a fan of the brand, I'm sure that is not something you intended or would want to see happen. Then they said when and if he reprints the book, they'd like him to consider changing the cover art, and if he wants to go ahead and do that now, they're willing to give him some reasonable funds for having it redesigned. This went viral in completely the opposite way as like the friendliest cease-and-desist letter ever, and it made the brand even cooler. So there's a lot of ways to accomplish what you need to accomplish. I had a client that makes dog biscuits out of spent beer hops, and all their marketing is from the voice of their dog. And another person in Colorado lifted their web content verbatim and put it in their dog biscuits out of spent hops. And the only reason my client knew was they didn't even change the link. So it would say, for more information, click here, to order, click here. So she was getting all these really bizarre Google Analytics. And when she went to see where they were coming from, she found it. She says, what do? I spent so much time writing that. And this, usually website terms and conditions are forms. There's not copyright, but this was oh, hi, I'm Spot, and I'm glad you're on my site, So I said, you know what, write them a letter from the dog and tell them to knock it off. And so that's what they did. We wrote it together, but it was in the voice of the dog, and they took it off immediately. I think sometimes people don't think, but that one was kind of funny. Keyword advertising. You pay Google, if somebody searches whatever, I want my company to be the first result in the Google search. Is that legal? Possibly, possibly not. Depends a lot on the circumstances. It comes down to, does it cause confusion? FTC, Federal Trade Commission, this is one of the places where they came down, and the case was ridiculous. Somebody searched Rosetta Stone, and their competitor came up as the first result. And the person said, wait a minute, this is unfair trade because I wanted to buy Rosetta Stone, and that's what I searched. And I don't even remember the other brand, this is horrible. And so the FTC decided that not everybody is computer savvy enough to understand what sponsored results are, which is what a keyword search is. So you probably don't even notice it. But now when you do a search, my search was fleece jackets, and the first 4 are sponsored that people buy for every time you search fleece jackets. Throw my site up there. You now have to have a little mark up there so people know it's an ad. And down here too, sponsored, ad, sponsored. So that's the FTC, the Federal Trade Commission, trying to protect people. Keyword searches can be legal because you're not violating the trademark of somebody else. What's not legal is meta tags. And that's where if you have a white background and you're selling Coca-Cola, in white text in the background, you write Pepsi-Cola, Pepsi, Diet Pepsi, Dr. Pepper, everything that's your competitors, and it brings them to your site, but people can't see why. That's not legal. That's all I was going to say on trademarks. Basically, for your purposes, you can truthfully advertise a connection with somebody else's. You can make a play on words as long as you're not confusing people. That's really what I want you to know. Defamation. This is a big one online. It's basically, a false statement that impugns somebody. In North Carolina, this law is so old. If you call an unmarried person unchaste, that's the actual wording in the statute. That is, you don't even have to prove damages if you've done that and it's not true. Big deal in social media. So how does it come up in social media? This case is from like 2009 or something. It was before we took pictures of tweets and put them visually. This was a girl in Chicago who didn't like her apartment and the management. And the management company, for reasons that I cannot explain, sued her. Nobody saw this tweet until they sued her for defamation. And her defense was, I didn't really say who I was, where I was, which apartment it was, what city I'm in. Nobody knows who you are. I haven't publicly identified you, much less defamed you. And the court said, yes, actually, there's enough there that you could figure out who it was, so possibly this is defamation. We're not going to dismiss it. More recent case on that was Rolling Stone did that huge expose of a fraternity that gang raped a girl. And they didn't identify the members of the fraternity individually, but they were allowed to bring defamation suits because it was easy enough based on other descriptions in there to identify who they were.
So even if it's true, it's still defamation?
No, the truth is a defense.
Okay.
It's an untrue statement. This is our latest, social media. This woman was one of the accusers of our president, saying that he acted inappropriately with her, and that was what he said on Twitter. And she sued him for defamation. The court ruled that this was so clearly hyperbole that nobody could believe it, and it's not really defamation. So, defamation, untrue statement you publish about someone. It's libel if it's written, it's slander if it's spoken. Truth is a defense, but it's very difficult to prove sometimes. Also, opinion and hyperbole are a defense. When the internet first started, there were chat rooms, not Facebook comments or that kind of thing. There were all kinds of defamation lawsuits, and the courts basically found that a chat room is just a room full of hyperbole, and you should take it all with a grain of salt. Nobody believes anything that's written there, and it's not defamatory. I haven't seen any cases on it, but I am sure in most cases, comments that get out of control would be under, this is either opinion or hyperbole. Also, you're allowed to have, comments and discussions on public policy, matters of public interest. Sometimes those get heated. Those are not usually defamatory. If you have blogs or comments on your website, almost always, if somebody posts something on there and you're not curating comments, anybody can post anything, you're not liable. You're not the publisher of those remarks. The one exception is if you edit comments and you edit a mistake in there, then you're liable, which makes sense. All right, right to publicity. That's what we were talking about, that picture of the girl in the rubble. Right to publicity is a privacy law. Privacy law is a state law, and it differs state by state. It's going to be really hard on social media if you put something on there that somebody else claims you violated my right to privacy, used my likeness without permission, because what state law is going to apply? Hopefully you have terms and conditions that says any dispute about this website has to be brought in North Carolina, but not everybody does. And so, if they live in Hawaii or Chicago or, Brazil, and they want to try to bring a suit where they are, you may be subject to their courts and their law. Basically, though, privacy law, some of it you can think about, Jackie Onassis on the speedboat and the guys with those huge telephoto lenses. She had expectation of privacy out at sea on the deck of a boat. If you're in a ballpark, if you're, a lot of times you'll go to a conference and they're going to say, this is being recorded, we're taking still pictures, we're taking video. By being here, you consent to having your picture used. I never do anything without explicit written consent about children, because the two ways you can make people the angriest is something with their kids and something with their dogs. I always err on the side of caution, and there are a lot of disclosures out. Every school I've ever had my kids attend, every Girl Scout troop, everything, it says, is it okay if we take pictures of your child and use them on our marketing materials? I always mark no, because I don't want her out there. I just, but and most of the time they're not really identifiable, and but you just need to say, this is what I want to do, is that okay? And you need to have a way to know if there's any that it's not okay, so you don't do it by accident. And I think that's almost customer service and dealing well with your market as it is legal, frankly. So right to publicity can also intersect with trademark law and copyright law. And I don't know that these are going to be anything that happens to you, but I think they're fun. This is Michael Jordan's 23 sneakers. This is the inside, I think, back cover of Sports Illustrated special edition honoring Michael Jordan for making the Hall of Fame. And this is Jewel Osco, which is a drugstore and grocery store in Chicagoland that put up this, you want to buy an ad? Yeah, we want the inside back cover. We're using his sneakers. And Michael Jordan sued them for stealing his right to publicity, basically, in a bunch of state law. And again, I told you change the facts, things changed. They said that, all this white stuff up on there was Michael Jordan's a local boy. We're so proud of him. And then Jewel Osco, and then 23, Air Jordans. They said that this was more about Jewel Osco trading on how everybody feels about the 23 and the Air Jordan than it was about congratulating him. And they found that under Illinois' law, this misappropriated his right of publicity. So this went horribly wrong. This is Katherine Hagel, who is an actress. She used to be on Grey's Anatomy, left and hasn't really done much since then. But she was walking out of her local drugstore, and she's carrying the bags, and the paparazzi snapped her, put it somewhere. The drugstore publicity department saw this, like, oh, cool, she shops at our store. And they put her picture, her name, her hashtag, their hashtag, and their slogan, the drugstore around the corner or something. And she sued them for misappropriation and unfair competition. I think this would have been completely different if they just said something like, wow, look who shops with us. Didn't name her, or, if their bags, the name on the bag had been facing the camera and they didn't really, I think that would have been just, oh, she's in a public place, no big deal. But they went that extra step. So just be careful if you have people. Here's some more of how it happens. For a long time, Facebook would use your picture randomly and put an ad to your friends that says, Donna likes NCSU social media program. Yeah, I use Facebook. They use Facebook, that's it. There are a lot of fake celebrity Twitter accounts. So now if they're non-verified or verified, because some of them are hilarious. There was one, like the Obama copy machine or something that was just snarky about the early days of the White House, and nobody thought it was actually, the teleprompter, it was the Obama teleprompter. Nobody thought that was for real, but sometimes, they're in the voice of characters on a popular TV show, and it's problematic to the brand owners. This one I think is bizarre. This is Humphrey Bogart in a picture from the movie Casablanca. And the Burberry company was doing a timeline on their website of their coats in history. And it's true. He wore that coat. It was made by them in Casablanca. He's been dead for a gazillion years. They put that on there. His estate sued them for using his likeness. I don't remember how it came out, but I just remember thinking, this is nominative fair use. It's true. He's dead. I can tell you, if somebody died in either California or Tennessee, there are huge rights for your estate to be able to control your image after you die. Think Elvis and every movie star that ever died in California. And that's why their state laws are very, very protective.
Imagine Marilyn Monroe, oh my God.
Yeah, so FTC has some stuff on your websites. If you have any kind of affiliation with a product, disclose it. They gave it to you free, they gave it to you for discount. You have an affiliate marketing program. Not rocket science here. Be transparent, be truthful, and disclose your affiliation. You'll be fine. This was a big deal a while ago. It's really not that big a deal now. Privacy policies. Mostly, you have to know what you collect and how you're going to use it. You tell people that, and you do what you say you're going to do. There are two kinds of websites. One is what I call a bulletin board. Here's my product. Here's how you contact us. Here's a picture of somebody using my product. Thank you. That's a bulletin board. You're not really collecting, you might do some analytics, but it's how many people came, what page did they stay on. Very different from e-commerce or sign up for my newsletter or more of a community bulletin board where people are interacting about how they use the products or service. You know, take a picture of your vacation, put it here. Where did you take the hat? That kind of thing. And people are putting their stories. You want to have a lot more guidelines on something like that so that if they put infringing material on, you're not in trouble. If they defame someone, you're not in trouble. You have community guidelines. You have the right to take it down or not post it. A lot of this is common sense, and you know, have a plan and follow your plan. And then employment law with social media. This is where people used to talk and gather about what a jerk the boss is today. This is how they do it now. Even if you don't have a union, and there are very few unions in North Carolina, the National Labor Relations Act applies to every company. And every employee has a right to gripe about the boss and working conditions, and is my salary more than yours, and did you get more time off, and this company stinks. When you do it on social media, companies get really upset because it makes them look bad, and they've tried to crack down on it. And there's been a whole bunch of rulings by a federal agency saying you can't prohibit them from talking about workplace conditions. And there's a lot of case law. Some of it I think makes a lot of sense. Some of it's kind of stupid. But just be aware that if you have employees, we need to really customize your social media policy for them ahead of time and apply it across the board evenly. Yes. Okay, depends where they are. Are they in the United States? If they are, they have a right to gripe about workplace conditions. That's an employment right. And there was an NLRB, National Labor Relations Board. Because there have been policies that say, you know, employees can't publicly disparage the company. Those have been shot down. The funny one was there was a BMW dealership that had a client appreciation day, and they were giving away free hot dogs. And one of the salesmen got on social media and said, hot dogs are really not commensurate with the BMW brand. And they fired him, and that was held to be, you know, that was okay because he wasn't griping about how he was treated as an employee, and okay, you know, they don't like what you say, they can fire you sometimes. It wasn't political speech. It wasn't, you know, my manager had the stupidest idea. It's just, this isn't part of our brand. So, you know, and if you work for someone, be careful what you say publicly. You know, I know you all have opinions and we have free speech, but only the government is covered by the First Amendment. In a lot of cases, you can say something stupid and be fired, and that's okay. I would look, I haven't looked there in a long time. I would look at somewhere called EFF, Electronic Frontier Foundation. They probably have one that's good. You need to think about what social media you're using, who else is using it. It could apply, you know, there's one set for employees, there's another set for people who interact with your website. And you just want to think about what you're using and what the rules might be. I would Google like a big fancy company like Fortune 500 that's in your industry and look at their website, but that's not going to tell you your internal one. That you probably need an employment lawyer to do. And that's my social media policy slide. That's all I prepared, so if you want to ask me questions after, I'd be glad to take them.
Yeah.
Thank you.
This is great. And you give a round of applause for this. Really excellent piece. And